presenters will be allowed to switch on their mics and also their cameras. During the question time, we'll be giving you an opportunity where then you will be raising your questions. And at that time, you'll be given the permission or an option to also to switch on your camera if you so wish. Thank you.
Hello. Hello, Kambula, can you hear me?
Yes, we can.
Okay.
Okay, the facilitators that are already on the platform, would you please just switch on your mics, your cameras, so that we can check the lighting and the positioning of your cameras. As you know that this is gonna go to YouTube, so the quality is very important. Would you please switch on your cameras for those who will be presenting. Okay, your lighting is not good, Kamogelo.
My blind.
It's still not good.
It's still
Very dark where you are.
okay. Let me try and move on to the other side.
Good afternoon, colleagues. Luando and Advocate Praise. There's a hand, I think, from Mateo.
Good day, everyone. Matsejo, I cannot see your hand, but you can actually show it.
Daddy Kunene, we have just been informed that it's you who's going to be moderating. All right. We have been waiting for Daddy Meshek. Has just informed us that your organization has assigned you to moderate this session. So we welcome you and we would like you to take over and do the moderation. We have one presenter and but I don't know whether Kamogelo, are you still there? Okay, was kicked out.
I see she is here. Let's see. She may be struggling with the network.
I've just admitted her.
Just want to check something quick. Sorry, I was talking to myself. I was asking if we're ready to start or are we still waiting for Kamogelo or our presenter?
Okay, Daddy Kunene, we have a challenge here.
Yes, Mami.
Our system is not good, is really giving us problems, the DOJ system, and unfortunately, Miss Lukubu Wilderson is connecting from the office. So we tried to avoid it by, getting out of the system of DOJ. So, but you have two presenters. We also have Advocate Advocate Molaudi is also here on the platform from the department, from the NPA. So I will say that let's start with her. And then Ms. Lukubu Wilderson will be joining us as soon as he has actually fixed a problem with the system. So over to you, Daddy.
Welcome, colleagues. I'll say colleagues because at the present moment we are all in the same space, looking forward to the same objectives and goals. So this is a session hosted by the Department of Justice, and I am Dedizi Kunene from Dads in the Picture. And without wasting time, because I see time has fast been spent waiting for other presenters to come through. So we will hand over firstly to Advocate Molaudi from the NPA to do the presentation, and then thereafter, we will then summarize the presentation and then take questions. So if you do have questions, on the chat, I see Abigail has posted that if you have questions, just click on the link there and then they will capture the questions and send them through. Advocate Molaudi, are you ready? Don't forget to unmute and switch on your camera. Let's see. There we go. I'm not getting anything from Advocate Molaudi. Right. The joys of e-system and technology, right? And we have to roll with the punches as they come. Me Likubu, are you ready to do your presentation? Please unmute. Okay, let's see. There we go. Are you ready?
Yes, you can flag. Are you flag the invitation?
Yeah, the audio is not clear. Your network keeps it doesn't seem to be stable, but you can keep talking. Maybe just introduce yourself, and then hoping that as you do so, it will get better.
Okay, I was just asking whether the presentation will be flattened from your side, or I should use my and the printed presentation.
Did you send the Luando? Do you have the electronic version of the presentation?
Still waiting for it. It hasn't come through.
Okay.
Probably it's network or something.
In the meantime, Lukubu, you can start talking from the presentation that you have, and then once Udeli Luando has received it, we can then share it with the audience. Over to you.
Thanks. Thank you so much for this opportunity. My name is Kamogelo Lukubu Wilderson. I'm the director responsible for maintenance in court efficiency within the branch court services. I have been requested today to make a presentation, and I thought that there are quite a number of topical issues that we could focus on. But I thought that let's look at the critical processes that are of challenge currently, not because of the legislative errors, but mainly because of various other pending issues around the implementation of the Act. And it has always been said, they say South Africa has wonderful pieces of legislation, but it's often a challenge to implement them perfectly. And as the director responsible for maintenance, I've been given the opportunity to look at the challenges, which I did in the previous financial year. We went through looking at challenges through the maintenance improvement framework. So this financial year, it is our responsibility as the department to implement the maintenance improvement framework. But this improvement is actually taking place in the midst of some serious challenges that we have that we may have to address through policy or through bilateral interventions, multi-stakeholder relations, and so on. But yeah, thank you very much for inviting me. In terms of the Act, I should say the maintenance is one of the most comprehensive pieces of legislation to address maintenance. And it's being implemented in the...
Ms. Lukubu, sorry to interject. May I request that maybe if you can switch off your camera, maybe it might enhance the quality of your audio. Thank you.
Okay, I'll do so. As I was looking at introducing the Maintenance Act, I started by saying that the Maintenance Act is a very comprehensive piece of legislation that really attempts to address the maintenance system in South Africa. And it affirms the constitutional right of children to being maintained as provided for in Section 28 and section 28, 1 and 2 of the Constitution. Therefore, it is an act that is progressive in nature and recognizes the rights of both children who are born in wedlock and out of wedlock. It therefore consequently affects children out of wedlock the same standard of living commensurate to his financial income. It must also be stated that both parents are legally liable for maintenance. So it's not a responsibility that is looked at a point of view of one party. It's a responsibility which the maintenance court looks at from the point of view of both parents. So that must be made clear, because I've often heard people saying that the system is biased towards women. It must also be said, and women proportionately affected and maintenance in a negative way. It is where children are affected by in a negative because mostly women are their parents that are left to take care of the children. So automatically, economically, it places them in a financial position to spend money for whether they like it or not. It is for instance from this point that it's a very important part of pillar 5 of the strategic gender-based violence. The process challenge and solutions we explore as part of the main improvement and into outline the challenge and try to in some see what the possible solutions that we can come up with from men's point of view. It's very important to know from the financial position of both parties in order for them to court.
Hi, Kamu. Your audio is so bad.
Yes.
And it's getting worse now. You have switched off your camera now. I don't know what else that we could be doing. But there's obviously
do this.
And is your presentation with you? Because I think that it could also help if you can fly to a presentation. Since Luando says that he has not received it yet.
It's with me, but I didn't know how to do that.
Okay, you click.
I'm suggesting that maybe I should ask a colleague if I could be connected from his office.
We have evaded the system, our work system. Luando is also not connecting from the office. I'm also not connecting from the office because we anticipated this problem from the morning when the system was unstable. So I will suggest that you, maybe we can show you how to flight your presentation. You go and click share. You open your presentation first from your documents. Start by opening it first, and then you go to click share. Share is there on the top bar.
Okay, I've opened the document from my documents.
Yes, you open it first, and then you go to to share. All right, you will see share. Share is next to
Is
that
it sharing?
icon. Yeah, you click there, share. It's that upward pointing arrow that is next to the icon of leave. You click it there, and it will turn, that arrow will turn into a cross.
Yes, click on the share.
Yeah, you click there. After we have clicked that share icon, then you will see that there will be an access to your documents that will be showing on the right hand side. Then they would reflect as like grayish. There will be a gray icon, but it's for your documents. Then you click it there. After you have clicked, then your presentation will show. And then you will click on your presentation and it will show on the screen.
Yes, it's showing on my side.
All right. I think it's gonna show it. You have clicked it. You have clicked it, the presentation.
Yes.
Okay.
Yes, ma'am.
I think it will begin to show. Yes, yeah, there it is. We can see it now. So just now, take it into the slide mode, the presentation on the slide mode.
Where would that be?
Or alternatively, advocate on the keyboard, you can press F5 on your keyboard. Press F5. It will start the presentation.
There we are. It's already on the slide mode on my side.
Okay. I think it takes time to come through on our side.
Yeah.
There we go. It's fine now.
Thank you. Thank you so much. Eh? You did so well. Thank you.
Thank you, colleagues. I really do apologize for the quality of the audio, and for could not leave the office to go home because I didn't know whether we are in load shedding or not. But we'll start with the presentation to say that we're going to look at the challenges that a few of the challenges that we have outlined or experienced in the implementation of the Maintenance Act, which is one of the most comprehensive pieces of legislation available in Southern Africa. The maintenance system basically affirms the constitutional right of children as contained in section 28(1) and 28(2) of the Constitution. It must be just stressed that section 28(2) of the Constitution is very critical in the interpretation of the provisions of the Act. And in my analysis, or a short-term analysis of having dealt with maintenance in the past year, I have realized that this section is not a section that maintenance court are critically aware of, because if we understand that maintenance system is basically affirming the rights of children, and that section 28, which requires that in all matters concerning children, their best interest is paramount. Now, when we interpret their best interest is paramount, we must understand the context of the duties that parents have to maintenance, their right to education. They have the responsibility to pay education, their living expenses, their medical expenses, and their social development expenses. And this needs to be understood by all role players who are engaged in maintenance. But unfortunately, this is not the case because often you find techniques being used in maintenance, and this is delayed in finalization of maintenance cases.
Excuse me, Mami Kamukalo. I don't know if you're still referring to the presentation, but we are still on the first slide.
I'm on the second point of presentation. I will.
Okay, maybe on your presentation, just press enter so that it can move as you present.
No, it's fine. I'm still on page 1 of the presentation.
Okay, noted. Thank you.
So the Maintenance Act is an act which is progressive in the sense that it recognizes the rights of both children born in and out of wedlock. This therefore affords both children the right to enjoy the same standard of living commensurate to their parents' financial income. We often find that when applications are made, the respondent wants to present his income statement and his expenditure statement, and thereafter decide to say that then you child out of wedlock, or as a child that I didn't, you can decide as a court how much this child is entitled to. And I think if we understand the visions in its totality, we should look at children who are born in wedlock or who are actually being maintained by the maintaining parent in the same way as the children who are outside of his home. Both parents are legally liable for this responsibility. And I was saying earlier that we often blamed as the maintenance courts that our courts are more disposed to listening to women than to the respondents. And my argument is that in terms of the NSP Pillar 5, it is an economic burden where the custodial parent stays with the child. Automatically, because they are a custodial parent, they will spend more money on taking care of the child. Hence, they have to recoup whatever financial expenses in order to ensure that they maintain the child properly. Next issue that we need to look at is that there are key challenges that we experience in the implementation of the Act, but these challenges are not because of the legislation. They might be because of lack of policy or protocols or the subjective nature of the outcomes that are given. And I would say that one of the key challenges that we have is access to financial information of any party who is part of the maintenance dispute. Now, in this area, the problems that we normally encounter, we encounter them in terms of accessing information relating to a person's earnings, because the maintenance officer will require to know how much a respondent earns in order for them to be able to guide the court on proper quantum. And this has been a challenge before the implementation of Section 9 of the Maintenance Act, which basically came with a new amendment. This amendment, which was introduced, maintenance amendment of 2015, basically says that all employers have to provide a maintenance officer with requested information if that information has been requested through a subpoena. And at this point has not sunk through to many employers. Actually, we have some challenges with some of our government departments who normally flash before us their own internal laws in order to circumvent providing information. And it becomes very uncomfortable to serve subpoena on a sister government department to force them to come to court to state reasons why they are not in a position and why the Maintenance Act does not supersede the laws that they actually state to prevent our acquisition of information. The other part that we have challenges with regarding access to financial information of parties is parties who have monies in trust. Let me call them monies on behalf of the respondents. Let's say the respondent is a director in a particular company. He earns some shares, or she's paid dividends on a quarterly basis or on an annual basis. The court will subpoena that particular company to provide us information and documents which would provide the maintenance officer with information to present to court. This person gets on an annual basis R1 million, or on a quarterly basis, he gets 600,000 rands, so that the court can be informed to make the right decision. In most cases, we have to subpoena or call these courts, these companies, to court before we even hear the parties. So this becomes a bottleneck in the system, but it's a bottleneck that we have to deal with in improving our own knowledge and systems to acquire this information. Then we have also a third class of people that we are unable, or we have some kind of challenges in ensuring that they pay maintenance to their children, that they pay maintenance, or the right quantum that will enable the child's rights to be covered. These are people who are often, we call them the unbanked, or people whose businesses are within the informal economy. And they form a large part of our society. And if we're unable to get their financial status or their true financial status, then it becomes very difficult for the court to come to an appropriate quantum for the child. So this is an area that we are looking at with very sharp eyes to ensure that our maintenance investigators are able to conduct lifestyle audits in order to give the court a perception on what kind of lifestyle, what kind of life is responded in order for the court to come to some kind of resolution as to the quantum that must be paid. Then what has the department done in order to address these issues? So far, in terms of
Kamo, may I just, because we are getting the comments that are coming from the audience, that the sound is quite bad, and it is bad. So I have actually requested that you go and make this presentation in the boardroom, DG's boardroom, where you'll be able to get the access to Wi-Fi. That will disconnect you from the system.
Will all the things be
Yeah.
Okay.
So I've
Help
just told them to ask them that they give you that opportunity. And I will then request then Dedi Kunene, if we can have in the meantime the presentation that will be done by the NPA, whilst Miss Lukobu Wilderson is walking to the other wing of the building. It's in the same building, so it's not going to take a time and connect there using the Wi-Fi.
No problem, ma'am.
Okay, Gina.
I also saw that Advocate Mulaudi was part of the meeting. I'm not sure if is still there. I'm looking through the list. Are you there, Advocate Mulaudi? I don't seem to see him. Colleagues, the nature of technology requires us to roll with the punches as and when things happen. So while we're still waiting for Umami Kamogelo to sort her technological challenges out, what we want to touch on, what I just want to highlight from what she has presented is that, one, South Africa is credited with having good pieces of legislation. And if then we are credited with having good pieces of legislation, what makes it difficult for the implementation of those legislation to happen equally as we have drafted those pieces of legislation? What is it that we really need to look at? And that's basically the topic of our webinar today, addressing process-based challenges in the implementation of the Maintenance Act towards maintenance services improvement. And maybe while you're thinking of the answers and the potential solution, let's also try to think of how is this impacted by the persons who are tasked to implement the very same pieces of legislation. I will open the floor maybe for some of your thoughts based on what you have heard so far. I will check here in the hands raised, so we don't see any hands raised at the moment. Is there anyone who wants to share their thoughts? Natasha, you can speak. You're welcome to switch on your camera and switch on your camera while you speak. Yes, Natasha.
Right, I'm in my car, so apologies for that, but this is important, so I thought let me just join. Thank you very much for the opportunity. I think it's a very good question that you raised, and my proposal or suggestion would be that civil society take hands with the people who is supposed to enforce this. There are quite a few people in civil society, and if I can just think on top of hand, mediators who really want to work with maintenance officers. But as a mediator myself, we do experience quite a bit of kickback from maintenance officers wanting to make life better for everybody. But we are seen as competition and as, lay people who don't really know what's going on. And it's causing a bit of...
calling you, ne? But I managed to get Ray to help me.
Oh, sorry. You may proceed.
Yeah, so it's just causing a bit of challenges, and I think we can definitely work better on that. So that is my suggestion, that civil society and maintenance officers take hands to address this, because we can do it.
Okay.
Definitely we can do it.
Maybe just as a form of engagement, and you'll forgive me, at times I like to be contrarian and also controversial. Mediators, are they seen as private entities who get paid for their services? Is that true?
There are, I suppose, the majority of mediators do derive an income from it, but there are also court-annexed mediators,
Okay.
who does work specifically with maintenance, And in civil society where I am, we are doing a lot of work pro bono in maintenance, but still we are seen as competition. And I'm speaking about, you know, a very recent 2 cases that I had, which is very frustrating. You know, so if we can sort that out, I'm sure we will definitely yeah, find a lot of common ground and take it forward.
Okay, thank you for your contribution, Natasha. And I'm sure our colleagues here have noted your contribution. The next person is Gregory Nyonga. You may speak, Gregory.
Thank you, Chair. I think a couple of things we need to be very clear that we may write as much policy as we like that, but if we don't change our frontline services, that's where the problem is. I think Malad is quite aware that on issues I've raised several times as well that, like now I'm sitting with a case in Pretoria, which has been going up and forth then in maintenance as well, that in terms of a certain lawyer who don't take responsibility in Pretoria, was resigned, threatened a woman now on the issue of it as well, that I will say that they want to break that case as well. But
okay, you say, sorry, you please try to slow down a little bit in consideration of the audio and just for us to get the gist of your point.
The biggest issue here is that we'll have to improve our frontline services on maintenance. That's the biggest challenge that we're facing in all the courts. One, women are becoming beggars most of the time. They decide that forever for the whole day to get attention on the work which needs to be dealt with by officials at the Department of Justice. Cultural Court is one of the biggest culprits of the issue. The appealing court also got the same problem, and another court also in Limpopo, the same situation as well when it comes to it. The second problem here is that the date issues then for hearings of maintenance sometimes takes up to 3 months, where the mother of the child needs money like now, like tomorrow, it's not coming around on the issues as well there. The third aspect is that when it comes down to the basis then of garnish orders, it takes up to 90 days before that can actually then be implemented. But by the time that comes there, there's a portion of arrears. That arrears is not coming up exactly at the same time as well, which is also a problem when it comes down to maintenance well. Then the fourth point basically here is that the issue of understanding the processes as women and men as well at the courts, it's another issue that which is also one of the situations that becomes a problem. And the last one is that these are taking joint responsibility in terms of what's for a child. And what is happening here that the arguments most of the time I cannot afford. But the point is that the person can afford alcohol and other things as well. And then when you start looking at maintenance cases, those issues with the lawyers are being dragged unnecessary. And that's a pain to women in society as broader issues as well. And the last one is that when the child then came to age and the maintenance order has been taken over by the child to take the father to court, that's another pain on its own because it means it's a new process altogether. That child is going to lose at school. The up and down to court as well, it just does become ridiculous, honestly.
Okay, thank you for your contributions. And I think part of what I noted there is the frustration with the lawyers, but mostly the process and also the frontline staff. And perhaps maybe that's another issue that would like our colleagues at DOJ to also talk to when they get an opportunity. Ronelle, you're up.
Good afternoon, and thank you so much for the opportunity. Sorry, I'm just unmuting. I hope everyone can hear me well.
We can.
Thank you so much. I'm a layman, but I am in the system currently. And what I would like...
By system, sorry, what do you mean?
Sorry, the maintenance system. Sorry, so I've applied for maintenance 7 May 2021.
Okay.
So it's been 15 months and I haven't even stepped into the court for Section 10 inquiry. What I would like to add, I think it was Gregory was his name. If I can just concur what he said about improving frontline service. I'll be quick just to add a few comments. What I think I think everyone should go back to the basics. If everyone just read the preamble of the Maintenance Act, I think it says it all. It's about implementing it. We have one of the best constitutions in the world, but currently that's not being adhered to. So imagine a class action of women, because that is possible, because the minute that your constitutional rights are trampled upon, the staff that needs to assist is actually contravening certain laws and trampling upon your constitutional rights. But there is quite a few challenges. But in light of the challenges, I would like to propose some solutions, possibly. I don't think it's necessary to reinvent the wheel.
Mm-hmm.
And what I mean with that is, I'm just going to make one example. Let's, if I can talk about a maintenance officer, for instance. There's an issue, and then you get told to please lay a formal complaint, which I understand. But let's be honest with one another. To lay a formal complaint with a person, a said person, with their senior, taking into account we all know what's going to happen, you will try and protect your own staff. And I think one of the major things that can be possibly changed is if you have a formal complaint, if there can be almost like an ombudsman, it should be someone independent that you can send your complaints to,
Mm-hmm.
but that same person or body or authority, they need to have authority to make decisions. So, because, you get told, send a complaint, and then that must go to the court manager, and that must go to whoever else. But let's be honest with one another. It's your own people you work with every day. It's your people that you lunch with every day. No one wants to actually, understandably, possibly so, but actually take action. And if there can be an independent body that those complaints can be sent to, but
Okay.
like I said, with authority, they should be able to make decisions. I just want to add quickly something as well. The emotional support. I think that's where advocate, I can't remember his surname, sorry, the one that made the presentation, did the presentation, sorry about that, I can't remember the surname now well.
Advocate Lekubu.
Yes, sorry about that. Regarding, it's always being seen as, women, you come to a maintenance court and you are being seen as emotional or et cetera, et cetera. But what people do not understand is that it is emotional because it has a huge impact on you as a person, your finances, etc. And I think what maybe if the department can consider this, I'm not sure what goes into training of maintenance officers, I'm not entirely sure, but to be able to work with people that's actually been through emotional trauma should, in my opinion, form part of their training.
Okay.
Yes. So sorry, I don't want to waste any more time.
Thank you. Before you step off, maybe one thing that I would like to ask is, should emotions belong to the court when such issues are discussed? Because then we're talking about money, we're talking about the best interests of the child. Should we really consider the emotional state of the mother, or should we consider the facts before us? And as I said earlier, I tend to like to be controversial and contrarian at times, so I'll kind of ask those questions.
Okay, thank you for the question. Unfortunately, it forms part and parcel of who a person is. You're not a robot, so there will be emotions attached to it. I agree. We should stick to the facts. Yes, of course. That's why there's a court, and that's why courts only look at the facts brought in front of them. But as a person, and I'm not going to say mother, because there's fathers also asking for maintenance. So as a person coming to a maintenance office or court, surely emotions will be involved because you're not a robot, and everything it's your children, it's your finances, it will definitely have an impact on you. Even though it is facts being brought to the court, you as the person coming to the court to lay down your case, there will be emotions. And it's not about being emotional, it's about you are frustrated because,
Okay.
so the facts, yes, that's what the courts look like, listen to, sorry, but we are not robots. There will always be emotions at play, whether you're a woman or a man, in my opinion.
Thank you, Mami.
That's my opinion.
So thank you, Mami, for your input. It's really much appreciated. I'm told that there is Advocate Refilwe from the NPA who can respond to some of these questions. Advocate Refilwe, if you are able to, please switch on your video and respond to those that you want to respond to. Advocate Refilwe, are you with us? Okay. Let's see while we're waiting. So I just want to also capture some of the comments that have been shared here, and maybe we can think about those as well. One comment here from Mami Ayanda says the process of maintenance is so painful and humiliating. Just like the current speaker said, we as moms become like beggars. I have recently transferred my maintenance case from Joburg to Brits. It's been 3 months. Every other day I visit the court. The issue is the system is offline. As we all know, those of us who've dealt with government departments, a lot of the times, the issue of a system being offline is one that we're all too familiar with. But what I'd also like us to think about is, through all of this, are we really considering the best interests of the child? Advocate Mulaudi, are you with us? Okay. Advocate Mulaudi, whenever you're ready, you can please switch on your video and then you can take on the presentation. In the meantime, I'll take the question from the hand from Matlakala Mpalo.
Thank you. Good afternoon. Am I audible?
Good afternoon, Dedi. You may proceed.
Thank you. I had one of the comments which were directly relating to the processes in the courts. And to be honest, it's also my concern to say when the complainant is coming to the courts, quite often they become in contact with the clerk. And the clerk, in most of the time, the way they are treating these cases is a cause for concern for me. I've been with the department for some years, so I know what I'm talking about. That is why there was one lady who was talking about a situation where she registered a case long time ago, but she never set a foot inside the courtroom. And my understanding is that when the complainant is coming to the court for maintenance, it's already a very serious case wherein maybe the person have tried all possible to get the money from the other party without success. So certainly the child is already in distress.
Mm-hmm.
But the maintenance provision, section 6, provides that when the complaint is registered with the maintenance court, the maintenance officer must investigate the complaint. But there's a blurry line there because the very same complaint is registered with the clerk, the maintenance clerk. It's not even registered with the maintenance office. At that time, the maintenance officer is somewhere.
Yes, I'm listening, Teddy.
Can you hear me?
Yes, we can.
I'm seeing something here on my gadget. I thought maybe I'm lost.
Oh, no, you're still with us.
So at the end of the day, the complainant will come to the court just to complete a maintenance application and will never see the maintenance officer for that day and go home and is given a date by the maintenance clerk who does not understand the agency. Who does
Urgency, yes.
the interest of the child. That is why the maintenance clerks, they've got no problem. Now is September, they can give you a date in December. It will be the first time that you will be meeting the maintenance officer to consult and investigate and look at the issues that are in dispute and so forth. And sometimes it's even very difficult to oppose even your own complainant. I'm not saying the complainant is the administrative, but what I'm saying is that is the one who is requesting a maintenance. For the first time, the maintenance officer is meeting the applicant. The applicant, remember, is the witness of the maintenance officer so that a proper decision can be taken that will benefit the child. But unfortunately, you find that there's confrontation even between the two of them. I'll give you a simple example. I had a case where the complainant came to my office to complain about the maintenance prosecutor. When that prosecutor was having some difficulties trying to assist the lady, because they don't even understand that the maintenance officer or the maintenance prosecutor is assisting them to present the case before the court. So for me, I think it's important to start looking at a situation where the applicant on the same day go into the court to complete a maintenance form. There should be a way in which the complainant must either see the maintenance officer or the prosecutor. And the other problem that we have is that from the prosecuting side, unfortunately, it is the honest truth, which I'm going to talk to it brutally. The prosecutors in all our courts currently, they see maintenance as something that is not even important to them, despite the provision within the legislation in terms of Section 4.1, which is making them the maintenance officers. But quite often, they are very less interested. And that is why the people who are going to feel the pinch are the applicants, because they will be frequenting the court without getting the proper assistance, because the very most important role players within the judicial system, which is the maintenance officer who must prepare the case so that it's ready for court, they are not there to assist them.
Okay. Yeah, thank you, Teddy, for that input. And while you're talking, something then comes to mind. Perhaps the legislation is good, perhaps the constitution is the best in the world, but do the citizens or do the residents of South Africa really appreciate the legislation? Do they really take it to heart? Or maybe let me not say do they. Do we really take it to heart? Do we understand its implications? Because if we did, we wouldn't be behaving the way we are at the moment. My argument is, if the officials who are tasked with implementing these very good pieces of legislation really understood the sanctity of these pieces of legislation, wouldn't they act differently? And maybe that's a point that we all need to reflect on. And as we reflect on that, I'd like to give Umami Hilda Hill a chance to speak. Mami Hilda? Hilda Hill? You can unmute.
Yeah, hi, can you hear me?
Yes, now we can.
Yeah, so I think I just raised one question which I did type out, but that is the shortages of maintenance investigators. There seems to be a problem here, and what is happening is the mothers are having to serve the papers on the defendant, because the system is failing us. And so I just want to know, are you aware of the shortage, and is this being addressed?
Thank you for that good question. Lack of capacity seems to also be a common thread, and maybe we'll also put that question to the officials. Yeah, it is a very good question to ask in terms of capacity.
Thank you. Thank you for the opportunity.
Thank you, Mami. Bethwell Mokoena, you're next.
Thank you. Thank you. I'm audible.
Welcome, Daddy. You may proceed.
Okay, thank
Sorry,
you.
just as
I
I
do
just
have
want can you just pause it for a moment? Sorry there. So any one of the presenters, if you are ready, excuse me, if you are ready, please switch on your camera so that I can see that you're ready and we can hand over to you. Daddy Bethel, you may proceed. Sorry. You can unmute.
Okay.
There we go.
Okay,
We can
thank
hear
you. I do have a question, and it's relating to two cases that I was working with recently. Yes, there is on the ground, there is understanding that the maintenance is only favors women than men. There is two gentlemen, these two cases. The first one, the gentleman, he have been maintaining the child for a year now. The child is 2 years. They separated with the mother, but he's denied access to the child. He have tried following the court processes and everything, but he's denied access to the child, especially during holidays as they are trying to co-parent. And really he's feeling very frustrated because he believes that he wants to be in the life space of the child. The second one is the same gentleman also here in the park for a 7-year-old, but for the past 3 years, he have been denied access to the child to the extent that the
We are losing your
child
audio there,
is
Daddy, a little bit.
moved to another province.
Mm.
He's maintaining the child while the child is in another province and the mother is. Can you hear me now?
We had you
Can you hear me
nicely
now,
there, and
colleagues?
then we started losing you there a bit. I don't know if you did move.
Hello?
No, we
Hello?
can hear you now. Please proceed. You
Okay.
said the same gentleman relocated, and then?
No, the child the child actually is the one who relocated.
Oh, okay.
She's yes, but the lady, the mother, still resides this side, but not with the gentleman. They are also separated. So it means the child is under the guardianship of a maternal grandparents. And for the past 3 years, these gentlemen have been denied access to the child. So I'm asking in those instances because you ask a very valid questions to say, are we? You said you asked a valid question whether emotions are considered in the court of law. So, but I believe as much as maybe relationship between parents have been broken, but the child needs both parents, and maintenance also cannot be viewed only
Daddy, your network is failing us there.
for financial. That is my question. Thanks.
Thank you. Yeah, I think another issue that we really need to consider and also interrogate, does maintenance equal access, and does access equal maintenance? And we really need to delve into that when we do have some time. I understand. Advocate Likubu, are you ready for us? Okay, please unmute. Unmute. We can't hear you. Still can't hear you.
Yes, can you
There
hear
we
me
go.
now?
Yes, we can hear you now.
Yes, I was saying that thanks for welcoming me back. Luando has my presentation. I'm wondering if he will flight it.
One other thing I'd
Okay.
like. Okay, maybe before you proceed, Mami, one other thing I'd like to request is that seeing that time has really been fast spent, sorry, if you have also been paying attention, if you've also been listening to the questions and the challenges that have been shared or while you were trying to connect, please do touch on those and maybe not go through all your presentation. You can just highlight key points that you want to share with us so that we are also able to get to our second presentation. You may proceed, Mami.
Okay. I had already alluded to the fact that the major challenge, one of the major challenges that we have on slide number 3, is access to financial information of persons against whom maintenance applications are brought. Often, there's a disproportionate number of women and children applying for maintenance. In order for the court to make a decision as to the quantum of maintenance to be paid, it is absolutely critical for the court to get all the information that both parties have. And we have been battling with people who are employed but refuse to give us their salary slips or their financial details. This has been dealt with in terms of Section 9 of the Maintenance Amendment Act, which now requires employers to give maintenance officers or maintenance investigators full particulars of those parties' earnings. And we hope that this challenge will be dealt with, but even government departments were still experiencing challenges, meaning that we have to subpoena people to come before court to explain reasons why they are refusing to provide particulars of earnings of the Party to Maintenance Act. So this creates a challenge in that it delays the process. We also have problems with third parties. And I made an example of companies where a person is a director in a company and this person earns dividends but refuses to highlight how much he gets. Then in this case, we also have the provisions of the new Maintenance Act or the Amendment Act to assist us, and third parties are required once subpoenaed to provide us with the person's financial details. The major problem that we're having currently is in the informal sector, where people are running spaza shops or shebeens, or they're running their businesses from the boot. They often come to court and say that they don't have any money, and therefore, because they are unbanked, it becomes quite difficult for us to trace how much of a maintenance quantum they could pay or how much they have, so that the court can come to a decision on the quantum. So we spend more time trying to dig deep into the person's financial details, and that delays the maintenance process or the investigation. The department has maintenance online track and trace system, which we use the credit bureau system in order to get information. But often this is not enough. We still have to do contact-based investigation. So investigation process as it's on its own is a challenge, and it's critical for us to be able to get information. Next slide. The next slide, slide number 4. The next area of challenges that we have is with future maintenance. Often when people resign from their employment where they are employed, they quickly dispense of the money in ways that is unscrupulous. They try to hide money. And as a result, if the complainant is not aware that the person has resigned, then the child loses on future maintenance. However, we have quite a number of cases that are in place that have said that we can attach a person's pension because there is no real provision within the Maintenance Act to enable us to attach pension. But through a number of court cases, we have been able to attach. But I must also mention that we have a discussion paper 157 of Project 100B, which actually put together a proposal on the process that must be followed in attaching pensions. So we hope that soon legislative provisions will enable us to attach. But it's also a bit of an uphill struggle because the complainant has to prove that, number one, she has to make an affidavit, and she must prove that there was an order in place, and she must also educate the court the basis of their application. You can't just say, just because a person has retired and they've got pension, they must attach the pension fund. You have to prove that they have failed on a couple of occasions to pay maintenance, and therefore you fear that if this money is not attached, your child will not have maintenance in future. And the next area of challenge that we have is access to information. This access to information is basically, whilst we can access information through credit bureaus and communication companies, most individuals and companies argue for the use of they use the Protection of Personal Information Act to try and refuse the court to access their financial information. And in this case, then we have to prove and we have to educate the individuals that the POPI Act itself provides for the department to get that information, because it states that where an individual is either acting on the basis of legislation or is a government institution and is carrying out a legitimate mandate of that particular government institution, they are entitled to get your personal information, whether be your earnings or your bank statements or any other financial records that we can use, because you are refusing to provide the court with that kind of information, either willingly or the complainant has proved that the information, the financial information that has been presented is not complete, that there's quite other sources of income that the individual gets, and therefore it must be accounted for in quantification of the maintenance payment. Next slide. Slide number 5. Then it is important to note that on the initial application, it is often well and fine for the court to issue a maintenance order. However, we often find challenges with parties that are not consistent in paying their maintenance, or alternatively, they just stop paying maintenance and do not come to court to indicate to the court that either my financial situation has changed or they apply for variation orders. In those instances where a variation order or a release application has not been done, the complainant can go forward and use various means to ensure that they have the maintenance for their child, or themselves in instances where the adult partner has maintenance order through divorce order. Then in those instances, what can the complainant use in order to enforce the initial order that was presented or the initial order of the court? They have to either, where a party, the respondent is working, then we can use a garnishing order. It's called the attachment emolument, or they can apply for execution of property, in which case we will attach property where the individual has paid up property or, paid up property in order to pay for maintenance areas. And in cases where that particular respondent is owed monies by other third parties, we can pursue the third parties to attach the debt to ensure that the maintenance area is paid, because it's the right of the child. And that is those areas that we have to look at. But there is another area that is becoming prevalent for people who are affluent, trust. People who are affluent like to hide their monies in trusts, and trusts are very complicated by their nature. But luckily enough, the Department of Justice has the master's office, and often with the working relationship between maintenance officers, maintenance investigators, and master's office, they may be able to get information. Where we have found ourselves kind of lacking because we don't have the capacity, or we're not educated enough on how trusts are configured in different ways. And therefore it takes a very intelligent maintenance officer or a maintenance investigator to understand how to pierce this corporate veil and how to identify the financial interest of the respondent in this trust once it is set up. But those are the issues that we're dealing with. We hope that the master's office, with the maintenance improvement framework, we will be having a relationship where they educate our maintenance officers and maintenance investigators on how to understand the different types of configuration of trust in order for them to identify the financial interest of a specific party. Next slide number 6. Here we have challenges, quite a myriad of challenges with serving. In order for a respondent to appear in court, they have to be served and they have to sign documents to show that they have received the subpoena. Often for people who stay in estates, or some people who decide that they're going to be recalcitrant, they just don't make access easy for our maintenance investigators. And in these instances, we have to basically work with police in order to enter, or we have to serve a particular body corporate with a subpoena in order to access the property or to access the respondent. Then there is another challenge that we're having, but that one the department is dealing with, is that we have about 400 plus maintenance courts across the country and only about 200 plus maintenance investigators. And they investigate financial information. The sheriffs often assist us with service, but it takes a maintenance investigator to serve effectively because sometimes it's a challenge for sheriffs to serve. Either because of the challenges that I've stated, that they cannot have access to the farm or they cannot have access to the estate, in which case they have to come back to court and we have to launch a particular court order to force the body corporate or the farmer to open, to enable the officers to conduct their duties. So the inadequacy of human resource and material resources also kind of sometimes are challenging in enabling us to carry out these subpoenas and the directives that are supposed to be served. However, currently with maintenance officers, we ought not to have a challenge, but these challenges are not really dealt with properly through policy direction. The inadequacy of the inadequate number of maintenance officers against the courts that we have. In that instance, we can use section 4.1 of the Act for prosecutors to work in maintenance courts. However, there are challenges because of the different policy directives that have been in place. And these are now being dealt with through the South African Law Review Commission amendment of the Act. We're trying to look at ways to deal with this loophole. In conclusion, I see my facilitator there. I will skip, I will go straight to the conclusion and say that the Act, by its nature, it's a comprehensive act. It's a beautiful piece of legislation where there are challenges. You can introduce amendments that don't have to be extensive like the one that the South African Law Reform Commission has done. And it is about strategies that we have to put in place in order to ensure that we are effective in implementing the Act. It is also about the stakeholder relations that we should have. Remember, this is private maintenance. We need to educate banks. We need to educate companies. We need to educate taxi owners to say that, please pay for maintenance for your children and also for your employees. Encourage your employees to pay for maintenance. We need to encourage people who are in informal businesses to say, once you have a child, in terms of our constitution, you are supposed to take care of their basic needs. So in a nutshell, I could say these process-based challenges are challenges that are not insurmountable. With efforts put together and stakeholders working together, I am sure we'll be able to fast track the completion of cases. But recently, I must say that I have confirmed through our statistics that we are able to finalize at least 75% of cases across the board within 90 days. It's the other percentage that we are worried about because no one child must go without food because their parent did not pay. So thank you very much for listening.
Thank you, Mami, for that presentation and for sharing your challenges. I believe, and maybe to all the attendees who are non-government related employees, excuse me, what we need to appreciate is that it takes a lot for one to be vulnerable and admit that they do have challenges, especially when that one is tasked with such a a sensitive issue around child maintenance, and there are so many dynamics around it that oftentimes we don't think about those dynamics. We don't think that even the state can have their challenges, that even the state can face certain resistance. But I'm glad to hear that, Mami, you have been working on solutions. And what I'd like to invite from the participants who are here, I see Advocate Mulaudi has dropped off again from the meeting. But from the participants who are here, what proposals and what solutions can we offer that would make the life of our children much easier, that will help eliminate the issue of parental alienation? Because we have to be honest and admit that families do use maintenance as a form of punishing the other party for not paying maintenance, so they just deny them access. And we need to be honest and honest and open about that, and say sometimes we fail the system as parents and as families and extended family members. How do we then, maybe, Mami, as another suggestion, is where the primary parent has failed to pay maintenance, why don't we go into their next of kins? But that's another conversation for another day. I don't want to open a can of worms right now at this point. What I'd like to put out there is, Advocate Mulaudi, if you are here, please do switch on your camera, and then you can take the set of questions, or if there's anyone else from the NPA who can assist, please do so. In the meantime, I'll open for the questions. Felicity, you're number one. Please unmute and then you can ask or comment.
Good afternoon. Can you hear me?
Yes, we can.
Okay, sorry, I'm also sitting in my car. We got load shedding. Okay, so for me, I've been working in the sector now for 8 years, and I really think that if we look at the Maintenance Act, it is purpose and around the best interest of the child, to protect the child's right to financial support from both parents. So if we look at so in the majority, it is women, okay? If we look at what is in place within the legislation to support that person who is trying to have the child's rights enforced, because in our Maintenance Act, in the procedure and the interpretation, there is very little support for the applicant. And that is part of the frustration, and speaking to one of the earlier comments, is the emotional side of it, because the pressure put onto the primary caregiver is enormous. And, you know, you alluded to that earlier, that often going to maintenance is the last resort. So the one issue is there's been a lot of negotiation, asking to contribute, that doesn't happen. And then eventually, out of frustration, they then approach the courts. On my group, Child Maintenance Difficulties in South Africa, I see the average age of approaching courts when the child is around 5. So that indicates that they anticipate an increase in expenses. So they've tried to carry the expenses up until that point, but they anticipate an increase of expenses when the child goes to school. That's one. And then it's a given that it's a child's right to financial support. It's a given that if this does not happen, that it's going to cause harm to the primary caregiver. So these are all givens. What is not taken into account is, with a high rate of gender-based violence, that a lot of the people, when they approach the maintenance courts, that they have experienced various forms of gender-based violence. They come out of domestic abusive relationships, and now they have to go and face their abuser in the court. So while the maintenance court deals with money, you cannot ignore the fact that they are now having to face their abuser again. So if we look at the domestic violence courts and the prosecutors, how they approach that, that is not taken into account in the maintenance court, yet it is an ongoing issue. I have one of my members who was, she was a hair's breadth away from death Okay, now she has a maintenance order in place. He's not complying because he's using the money to continue punishing her. She now needs to approach the court to enforce it because she can't financially cope on her own. I advised her to walk into the maintenance office and move the chair to a position where she's comfortable, because automatically she's sitting right next to the person. The maintenance officer is not aware of the history because this is about money. And I advised her to move her chair to a place in the office where she feels safe. When she did that, the maintenance officer said, "Why are you moving my furniture?" And she said, "Well, I don't feel safe. I have a protection order." And she says, "Yeah, well, that's only valid for 3 months." That is not the case. So there's a lot of secondary abuse that takes place within the system by proxy, by attorneys, and unintentionally by the very people that are there meant to protect the child's rights, but there's no protection for the person trying to protect the child's rights. And then we become too focused on the legislation and sticking to all the legislation, which is such a contradiction, because if a couple walk in and the maintenance officer, which is the norm, says, "How much can you afford?" 500 Rand. If the person approaching the court is not informed of process, which there's no expectation that they have to be because they're not legal people, they don't study it, they approach the court with the assumption the court there is to protect the child's right and knows the process, and they will automatically be
Okay, looks like somebody muted us.
I'm nearly finished. Sorry, I'm nearly finished. That
Okay.
they accept 500 Rand, okay, which is totally inadequate. He can afford more, but that is accepted, okay, which is not in the best interest. Okay, I'm finished.
Somebody keeps muting us.
I think I've
Sorry.
made my point.
Thank you for that input. It's and I saw Advocate Legubo was taking notes there. I'd like to ask Advocate Mulaudi to address some of the questions that have been asked. Advocate Mulaudi, please unmute yourself and then speak.
Good afternoon, colleagues.
Good afternoon.
I've been struggling a lot to get hold of the audience. Moderator, I don't see the questions, but let me respond to this, the last question from the speaker.
Yes.
Yeah, because we need to talk about the practical implementation of the Act, the challenges. I want to start by saying, whatever she's saying, it's true. It is true precisely of the fact that you'll find that some people are not trained when it comes to the issue of social context. For us to understand where maintenance come from and where we are going as a nation, we need to get to basics and understand where does maintenance concept come from. I think it's very important for all of us as stakeholders, including our NGOs, to be trained on social context. Social context as a topic when it comes to maintenance issues is very important. So as we'll be able to understand the dynamics, especially the cultural dynamics, the social beliefs, and our religious beliefs as well with regard to maintenance. Because at the end of the day, if we are trained on issues of social context, we'll be able to understand where we come from maintenance. Colleagues, I want to clarify this aspect with regard to Section 4.1 of the Maintenance Act. It is clear that we don't have to dwell too much on the law. We need to come up with practical challenges that we experience in the maintenance courts. But before I unpack it, I just want to indicate my responsibility. I'm the senior maintenance prosecutor in the Northern Cape, in NPA. I work very closely with Advocate Nyamandi. I think she's on the floor as well. Director Legal Administration, Northern Cape. Section 4.1 of the Maintenance Act is one of the things that, firstly, when we started with regard to amendment, it needs to be amended, definitely. Because of when you look into Section 4.1, prosecutors are appointed in terms of 4.1. 4.1.2 is Department of Justice of maintenance officers. But now, when you get to some court, you are not going to get a maintenance officer appointed by Department of Justice in terms of Section 4.2, precisely because of the fact that The Department of Justice does not have maintenance officers in all the courts. Now, prosecutors are maintenance officers of the corresponding court, meaning if the maintenance officer is not available in that specific court, maintenance prosecutors must do maintenance matters there. But what we have done from our side to ensure that at the end of the day, and the last speaker indicated something very crucial to say that some of them are not yet sensitized when it comes to issues of maintenance. I'm not going to defend the organization. I'll say, as senior maintenance prosecutors, we are rolling out training to prosecutors to ensure that they are covered when it comes to social context. They are covered when it comes to the issues of informal inquiry, because I saw that some of them, maybe they are not clued up when it comes to maintenance matters. But what we do as senior maintenance prosecutors is to ensure that our prosecutors in the provinces are trained, including the social context as well.
Yeah,
I don't see another question. I don't know whether I covered that aspect.
Yes, maybe what I'll do is I see there are hands which are still up.
Yes.
And we will take them one by one. How would you prefer, answering after each question or waiting for all of them?
I prefer to answer after each question.
Okay, we'll take Ulebogeng Mokhosane. Ulebogeng, unmute and then you may speak. All right, we can move on to the next one. Eugene Opperman.
Yes, thank you so much for the opportunity. I'm an attorney. I've been practicing in family law for the past 22 years. I've been listening to all the speakers now, and I do not think that the Act is the problem. I think our Maintenance Act is very much on par with international legislation pertaining to maintenance. I think it's more of an enforcement problem. Enforcement to and I'm speaking specifically to the training of the maintenance officers, and I also speak to the training of the judiciary. Recently, I came to about stats that was given to us by the Minister of Justice. And just for an example, they say that the Strand Court in the Western Cape has had 165 cases per year. Now, that amounts to basically 13 cases per day or per month, which is ridiculous. I've been in the Strand Court basically each and every day, and it is ridiculous to think that they only attend to 13 cases. So definitely the stats, in my opinion, is massaged. The amount that is not finished, and I respectfully disagree with it, with the 75% of the cases being settled within or finalized within 90 days. I do not see that. Sorry, as a legal practitioner, I definitely do not see that in courts. My suggestion, what we did to Advocate Rodney Isaacs, he's the provincial head in the Western Cape. We actually made a proposal, coming back to the speaker's question pertaining to suggestions that we should deliver to make the system better, was that to implement courts on Saturdays, family courts on Saturdays, because some of the moms cannot attend court in weekdays. They cannot afford, they basically cannot literally afford to go to court, taking off work for days on end, standing in queues to settle that. So that was a suggestion, and that suggestion actually came from 2014, when the South African Law Reform Commission made that suggestion. And that was discussed on the latest amendments as well. And we are also making proposals to the Law Reform Commission and to the provincial heads to implement a system where they can use a commissioner of small claims courts to assist, because they are familiar with the court processes and they are willing, there are people willing to assist DOJ in covering the backlog in order to expedite the maintenance process.
So maybe my question to you too, actually, is one, those people who are willing to assist, at what cost, and could there be a reasonable rate that can be determined if there is a cost to the assistance? And then secondly, we have an issue where I am and in my experience, for if you introduce an additional working day to certain sectors, you get this thing which is called overtime, and it tends to be open to abuse. And how do you then monitor that the officials who are working during the week, they do their full duties, they apply themselves fully during the week as much as they would on a Saturday?
I think there are many commissioners of the small claims court. I know of 3 people in the Helderberg region that are actually prepared to sit for free as a pro bono, as a social responsibility to
Okay.
they're prepared to do that on a Saturday to assist the DOJ with a matter.
Okay, DOJ, please make contact with Attorney Eugene Opperman. Please do share your details on the chat, maybe.
Yeah, I think that suggestion has been made in the Western Cape, and he says that he has been talking to the provincial head on this matter. So I believe that within his, yeah, I think they will take it on as the department in the region. But I have taken note of the suggestion in terms of the sitting of the courts.
Okay.
And as far as I just wanted to say
yes,
that
please.
My major worry is that we still have to work very hard on producing the quality of reports, of financial reports, that enables the right to have appropriate quantum of maintenance.
Yeah.
And it is, I just wanted to also acknowledge Felicity, who has been working with the public and educating people, has a platform where she has more than 400,000 people that are connecting to her. And I will say that I agree with the issue of sensitization. We will definitely take on the issue of sensitization of maintenance officers, and we will also talk to the sergeant on sensitizing the judiciary. I just wanted to add a little bit more complication there. It is true, you know, maintenance cases take place within district courts. And as a result, you get similar cases having different outcomes. So in that situation, it is quite unfortunate that we end up with a child getting 500 rands instead of getting 1,500 or even 11,000. So currently, we are focusing on ensuring that our maintenance investigators can give us the quality of reports that enable us, or that will enable the maintenance, the magistrate who sits in the inquiry to come to a reasonable quantum. And I'm very glad that Mr. Mlauzi has clarified the fact that, in fact, Section 4.1 provides for the prosecutors to work as maintenance officers, but it is probably we need to have internal communication between the NPA and the department on how we bring this together. We bring the work of maintenance officers in the NPA sphere and our sphere together, and we're working on developing a protocol and a model that will enable us to actually keep track of the cases that are finalized and not finalized. The statistical issue that has been raised, I believe that, yeah, it's within the learned lawyers' right to have a difference in opinion. And stats are stats. We definitely will look at the stats of the Western Cape to see what could have, it doesn't make sense for a court to get 13 applications per annum, or even 133 applications per annum. Thank you.
Thank you, Mami, for that. I'll take the next remainder of rounds of questions. The last person will be Nolita Madiba, and I'll take them in the following order: Natalie Reuters, Gregory Nyongane, Masego Modisane, Matlakala Mthalo, and then Stephanie. Natalie, and please make your questions direct and to the point. Would love to give you a chance to do your preamble, but unfortunately time is not on our side. Natalie?
Good afternoon. I'm not sure if you can hear me. I'm load shedding, so my Wi-Fi is a bit unstable.
We can hear you.
Thank you. So I appreciate that the various departments, DOJ and MPA, are being vulnerable in their lack of and where their struggles are. However, when civil society, and I'm a court, so I do court and next mediations in the family court and the domestic violence court. And what I find is there's a whole lot of red tape. So while we're trying to achieve Section 28 to get the child's best interest in place, and what I find is when we do parenting plans in the children's court, we cannot separate parenting, care and contact from child maintenance. And the erroneous parenting plans we are using currently does make provision for a maintenance order. However, the magistrates and the staff in the children's court do not want us to address it, but rather tell the mothers to go down to the maintenance court. And in my opinion, we're not bringing justice to these women. Most of the respondents are the women in this case when we're doing a parenting plan. Yet, Section 16.2 says any court can make a maintenance order. So does the Children's Act 33(3)(b) also says that a parenting plan can make a provision for maintenance order. So I don't really understand why when you ask civil society or us to help you make the process a bit smoother, we get so much red tape. That's the first thing. I remember doing a case with a mother who was brought in by father. Father wanted care and contact. She hadn't denied him of care and contact. Her hesitance was every time she needs to send the child to the father, she has to provide milk and nappies to go with the baby to see the dad. But the father is working. The father is not paying maintenance. The clerk who opened the application for the father to come and get care and contact did not ask whether the father was paying maintenance. So when we had completed the parenting plan, putting care and contact into place, I couldn't assist the mother in getting an interim order. And that's a huge problem I'm finding in the children's court. I also did another case in the domestic violence court, and it had nothing to do really between the partners, but it was an extended domestic violence with family and inheritance and that kind of thing. But while I was doing the mediation, I found out that the one couple had an issue with maintenance, child maintenance. So once we had wrapped up the bigger mediation, I sat with the couple. I managed to get a 50% increase on child maintenance. However, when I went back to the clerk and wanted to make this an order, I was told the domestic violence court cannot make this increase an order. So I went down to the maintenance court, and the maintenance court said they cannot make this an order because there was not a formal inquiry. When I spoke to the magistrate, her words to me was, this is not an increase because it's not an order. Yet the father has agreed to paying this 50% increase, and there was an agreement between the two. And
Yeah.
in the Maintenance Act in Section 6, it says
Natalie?
any written or verbal agreement can be enforceable. So we had this verbal agreement between the two mediation in the domestic violence court. Why was it not enforceable?
Okay, thank you,
There's a lot of
Natalie.
red tape.
Thank you, Natalie, for that one. Advocate Likubo, maybe that's another thing that will need to be discussed extensively. But for now, can I just take the next round of questions?
What I wanted to stipulate is that, Natalie, it's true, the different types of or different pieces of legislation provide for some form of resolution of maintenance issues, and these have there's nowhere where we tie them. And I guess it's one of the issues that we would have to look at. It's a process issue that would have to be looked at. I've documented it, I've heard about it before, and we will definitely look at how we tie the domestic violence court orders relating to maintenance, the family advocate agreements made, and how do we bring them to the informal inquiry, because we don't have a provision within the Maintenance Act that allows for private mediation consent agreements to be brought in. But I don't think there is anything wrong with the parties. If you are a mediator, come with the parties, lodge an informal inquiry, and if we like consent orders, that is a consent order. It needs to be confirmed in front of the magistrate. So your informal inquiry, lodge the informal inquiry. It's easy. You're not going to discuss the issues because the issues would have been written down and signed by the parties. Then we make provision for the parties to appear with the agreement that has been facilitated by a private mediator in front of the magistrate, so that the magistrate makes that consent agreement a court order. So in terms of this particular problem that she was mentioning, it can be dealt with like that. But the fragmentation is there, and probably we have to look at how we harmonize the fragmentation in respect of maintenance, because clearly domestic violence is just one, it's an aspect that may be part of domestic violence. In mediation, in divorce matters, maintenance may be an aspect. But I know in terms of court orders that are made in divorces, those are enforceable in court. I think the problem is we need to discuss with the family advocate to see how those agreements are brought in the maintenance court purview and formalized. Thank you.
Thank you for that. Natalie, as a suggestion, please drop your contact details so that they can also follow up with you and you can engage, in providing alternative solutions, because that's what this platform is here for. We want the solutions to the current challenges that we face. And maybe also share your wisdom on how you got the other party to agree to a 50% increase. Maybe it will help as well. Thank you.
Thank you.
Gregory?
Thank you, Chair. I think that what is happening, a number of things that we raised today, that it simply means that we need to have an alignment between regulations coming up on the Domestic Violence Act and review some regulations that MNTS Act as well, in trying to cover those loopholes where it's being raised here today. It's very critical. The second thing is that we also have to have a look at the way that how do we strengthen then our electronic digital system as well. Example, it's quicker to get your information on ITC, not being aware that you're on ITC on information with link for SARS and other parties when it comes to that as well. That maybe it's time that the issue of financial information as well, Amendment X should be looked at how then we get information of parents paying responsible for maintenance, so that when IT is also updated that information, the information are there in order that the pay slips and whatsoever can balance on the basis that on a training system where it comes to. Another issue also we need to have a relook at is the question of that we need to have a clear definition role of investigators and what is our powers when it comes to that as well, because there's a big issue of investigators. Some will do the work, some won't really do the work as well. That there's also lack in the regulations that to strengthen then the basis of the role of investigators and maybe give them away some sort of powers or a way that we have a look that as part of GPS class, how then we start looking into the issue of investigators. Then the last one, which is very frustrating, is also the backlog. Maybe we should have a look then, can we introduce then what we call a night court from 5 to 8, for instance, where then the night court can become then a backlog court to look at issues being raised here so that we start looking to the night code and say that we just deal with our maintenance as a pilot. Then from our maintenance, then we'll also look into future maintenance as well and start looking at those cases to reduce the burden then until it comes back again to that regulation will have to be amended to accommodate this issue as well. Thanks, Chair.
Thank you very much for that precise and straight to the point contribution. I'm sure I saw Umameka Mugelo just writing away. I know she's taking notes. And her colleagues are also there. Maybe the next one is Stephanie Erasmus. Will you please also make it straight to the point and short and sweet? Maybe it will not be sweet, but short. Stephanie?
Thank you, Mr. Chair. I'm Stefanie Erasmus. I'm Senior Maintenance Prosecutor of KZN. I would like to say the following. First and foremost, I agree with Advocate Opperman. I think Eugene, or is it Mr. Opperman, attorney? My apologies, but it's irrespective. He saying that the problems doesn't sit with the law, but with the implementation. We train maintenance clerks, investigators, maintenance officers and prosecutors across the country. What is happening is day after day we discover that they do not understand how the legislation works in practice. And here is the nutshell. The applicant should submit her supporting documentation when she applies. If not, she should submit it on the first occasion that she appears with the respondent on the Regulation 3. But by that time, his documentation should be there as well. If it's not, he should be served with the Section 8 subpoena to submit his documentation within 14 days and be held in contempt if he doesn't do so. Failing which, the matter can be referred to the maintenance investigator to investigate. This will alleviate the problems with investigators being inundated. Also, the other issue is that investigators is supposed to be instructed by maintenance officers as to what to do. Maintenance officers is supposed to, after an application, to make a decision whether to call parties to court with a directive or to issue or to ask the investigator to investigate parties, and the maintenance officer should make that call by law. That's not happening. That call is being made by clerks. So I agree that staff-wise, we are understaffed, undoubtedly. And that creates a whole, how can I say, domino effect as things go lower. With regards to interim orders, I agree they are not being used enough and properly, again, because of a misunderstanding. The average person at the maintenance court think that the parties need to agree to an interim order. That's not true. Section 10.6 is very, very clear. The magistrate must make that call on a request of a maintenance officer, but that's not happening. Why? Because we don't have documentation. Why? Because parties were not forced to bring their documentation day one. So we're back at the start. With regards to mediation, yes, you can mediate, but the magistrates still have judicial oversight. Hence, the documentation needs to be on file so that he can quickly have a look through that, establish that the offer that have been made is within the means of the parties, income and expenditure of both parties, and then to go on and make that order, final. That also to happen. With regards to the suggestions from here, please note that a draft discussion paper has been provided for input by the Law Reform Commission. We really need everybody's input on that document. I find it strange that legislation is being lodged in Parliament by a political party whilst they haven't submitted any inputs on this draft discussion review paper, and the same. I'm not sure. I know there's a lot of people attending here. I can see the guests who has submitted input on that draft discussion paper. But let's have the Law Reform Commission have your inputs there. Let me leave it at that. Thank you, Mr. Chair.
Thank you very much for that comprehensive input. I know and I've seen that all of it has been taken into consideration. Now we'll take the last two questions, also to be just short and to the point. Nolita, and then the last one, Uleboheng.
Thank you, Chair. I'm Nolita Madiba, the SMP in the Eastern Cape. Fortunately, I spoke after Steph and she has covered most of the things that I wanted to cover. But what I want to touch on also is on capacity as far as investigators are concerned. I know Kamukelo mentioned something about capacitating the investigators, but the problem is we don't even have those investigators. Can we have staff to do the work? Because you find that you have one investigator who is in charge of 5 courts, and it does not do justice to the other courts. And also, I wanted to touch on the issue of the prosecutors doing maintenance. Yes, prosecutors understand that they are maintenance prosecutors in terms of the, they are maintenance officers in terms of the Maintenance Act. But the problem is we don't do justice to maintenance, because in those courts where you have one prosecutor, that prosecutor has got his criminal court role. He will not he will not give preference to maintenance. You know, at the end of the day, you find that when it comes to maintenance, those cases will be postponed. Hence, we have cases that are not being finalized because we have one prosecutor who has his criminal court role already. Even though they want to assist, they can't because they've got their own criminal court roles. So we as far as capacity there is concerned, we still have, we need maintenance, we need specialization. That's what I wanted to say. We need people who are dedicated to maintenance, not just criminal court prosecutors who are there to assist in the absence of or when it is convenient, or when they are not busy with criminal court, because we'll keep on having these problems of not finalizing cases if we don't have dedicated personnel. I know this has been mentioned also in the draft paper. Lastly, on the stats, the issue of stats, I know it's a thorny issue, but we'll keep on having problems with the stats because we have 2 stats. If we have stats for NPA and stats for justice, those stats do not tally, and they will not tally anytime soon, because we require different things from NPA, you require different things from justice. If we can have one stats form for maintenance, I think it will alleviate the problem that we are facing with the stats presently. Yes, that's what I wanted to say. Steph has covered most of the things that I wanted to say. Thank you.
Thank you, Mami Nolita. Uleboheng?
Colleagues, can you hear me?
Yes, we can hear you. Please
Okay.
proceed.
Yes, I'm Oleboheng from the Nigel Magistrate Court. I'm actually concerned regarding the issue of the order that was mentioned in terms of the Children's Court.
Please proceed. We seem to be losing you there a little bit, but try to continue. We'll see if we can pick up your audio.
Oh, yes.
No.
Because there was an indication that, hello?
Yeah, your audio was breaking there.
Is it much better now?
Yes, please proceed.
Because there was previous an indication regarding the order of the Children's Court, where the Magistrate Court has ordered that a maintenance must be paid and it could not be enforced when there was a failure to comply from one of the party, as well as the domestic violence order. But I also want to refer our colleagues to Section 1 of the Maintenance Act, as well as Section 3, as well as Section 6. Maybe if we can deal with specification with regard to the one under Section 1, when it says maintenance order means any order for the payment, including periodical payment. So I'm of the view that when that order was made for a periodical payment of maintenance, it was either made in a children's court. I don't see where is the problem in having to enforce that order, because there is an order with specification regarding the issue of maintenance, and many orders like that has been also being enforced. You will recall from Advocate Lekubu when she indicated that it is the same as the order of a divorce order in the regional court, either regardless of either Rule 43 or 58 or a divorce order. It can still be enforced again at the magistrate court under the maintenance court when it orders the issue regarding the maintenance. So my plea is that my heads there, let's try to maybe bring training down to our admin clerks, investigators and officers, because one thing that I'm picking up here is with regard to the issue of maybe the lack of information, because it says any order that is made by an order made by any court. So if then the other court is going to make an order which the previous court has already made, it's just going to be a duplication of an order.
Yeah.
On that.
Thank you very much for that valuable contribution. Once again, the common thread that's coming through, Mamika Mukhela, I'm sure you would also attest to this, is training, and as well as capacity. That if we can at least resolve those issues, maybe we'll start seeing some headway. We've had some people offering their services here to assist, and I hope that you do take those to consideration. Advocate Mulaudi, you can give us your closing comments, and then we'll give Mamika Mukhelo her closing comments as well, and then we close the session.
Okay, thank you very much, moderator, for this session. I just want to indicate that it's very exciting to see other stakeholders being involved in maintenance. It's exciting to hear attorneys who are dealing with maintenance matters. Colleagues, maintenance is a collective effort. And one thing that I want to raise going forward, I think it's something that
Okay, we've got that gremlin that keeps unmuting us. Please unmute Advocate Mulaudi and continue. Yeah. Somebody keeps muting. Let me see.
Okay.
Yeah.
Am I audible now?
Yes, you are.
Yes. Where we have our maintenance forums, where we'll have our recipients, where we'll have the sheriff. I just want to tell you why maintenance forums are important. When you look into the section 27 is underutilized. Attachment of property, precisely because of the fact that the Department of Justice does not have a specific budget where it caters for this attachment of properties. You'll find that the property is attached, but at the end of the day, the sheriff cost will be more than the value of the property. So it's very important for us to have sheriffs in our maintenance forum so as we can work with them in deserving cases. They can work pro bono to assist the maintenance recipient. And it's very good that we have attorneys who are interested in dealing with maintenance matters going forward, because we'll need them at the end of the day. At some point, they'll need to work pro bono to assist the maintenance claimants as well. Secondly, Mr. Nyongani indicated an issue of investigators. Yes, it is true that investigators must be capacitated, but their powers are outlined very clear in terms of Section 5 of the Maintenance Act, what they are expected to do. But at the end of the day, we need to capacitate them to ensure that going forward, they work effectively. And also, there are instances where we need to charge employers for interfering with the duties of the maintenance officers. The Act is very clear on that as well. Secondly, the last point, we need to retain our maintenance officers. There will be crisis in this country, because the problem is, if we don't retain them, we don't have a retention strategy, they are going to leave. And they are leaving province by province, precisely because of the fact we can't retain them. These are legally qualified people with LLB who are employable at any institutions. And if we don't have a strategy to retain them as the Department of Justice, working closely with other stakeholders, we are going to lose them, and then there's going to be crisis in this country. Thank you very much.
Yeah, thank you for that input, Advocate. I think it's sobering, as well as the issue of retention is one that I think most of us have not really taken into consideration. Mame Kamukelo, you can have the last word.
Okay, thanks a lot. I don't want to take away from what people have already said. We take to heart the new suggestions that we don't have on the radar, like using.
There's that gremlin that has muted you, Mami, again.
Yes. I'm saying thanks for the opportunity. What I wanted to say is that I don't want to take away from all the contributions that have been made. And we will definitely, we are at Eden in quite a lot of areas, but the new areas that have been made, like the suggestion that we have after court our courts to try and accommodate more maintenance applicants, it's very important. The issue of maintenance investigators is an issue that is close to my heart, because if we have 239 maintenance investigators dealing with 400 plus maintenance courts, definitely we're going to do some kind of injustice to the investigation that they're doing. Definitely there would be backlog. And I think the issue of tying the various pieces of legislation to make sure that we all at Eden on how we enforce the Domestic Violence Act. And lastly, the biggest issue is stakeholder management. We need continuously talk to the stakeholders, because remember, this is about private lives of people. So if you want to include a third party, they are often resistant because people don't want to be drawn into issues of intimate family issues, and they try to stay clear of that. But we need to educate our stakeholders. We need to recommit ourselves. We need to make sure that we have more maintenance investigators who can deal with cases effectively, and we need to train. And I must just indicate that the National Prosecution Authority has been our champion in training the maintenance officers. So at least in as far as that is concerned, it's something that we have agreed upon, but we are going back to the drawing board to see the areas that are still lacking, to make sure that both the Justice College and the facilitators from NPA close those gaps.
Thank you very much for that. We do really need to close the gaps, but also another important thing is the collaboration between the government departments. And as soon as we make way in that, and also bring on our stakeholders and you know, make them feel heard, make them see that their contributions are valuable and that they are making a difference, that will go a long way in helping us and our country, but most of all, helping our children, because what is tomorrow without our children? What is tomorrow when the children are going hungry, when the mother is frustrated, or when the primary caregiver who has the care of the child is frustrated because somebody else has found a way to manipulate the system to their advantage? You know, we really need to take stock of where are we as a society? Are we really taking care of our children? And we need to take that step back. And I hope that we then have a part 2 of this conversation where we look at the role that non-state organizations are playing in frustrating the whole process, because then we will unravel a lot of it there and find solutions around that. But thank you From Dads in the Picture, thank you for giving us this opportunity to moderate this very important conversation. To each and every speaker who has contributed to this important and pivotal conversation, we really appreciate your input. Mami Kamukhelo, I know you've struggled with network, but eventually you made it. I don't know if Advocate Kambula, you're still here to just close us off and release us so that we can then think through all the suggestions that we have heard.
Thank you, Daddy. Thanks for the moderation and also to all other speakers. And as the National Strategic Plan, Pillar 3 collaborative, as I'm listening here, is that we need to have a follow-up webinar on this topic. We included it because we know that it is one of the core drivers for gender-based violence and femicide in the country. So we will definitely do another one. And it has been eye-opening to us. And I have seen here also Anonisha, who is also the co-convener for Pillar 3, for the NSP Pillar 3, is also here on this platform. We will definitely have a follow-up and ensure that the judiciary is also here, and also, you know, all those who have an interest in this. So I will say that, please, if you would want to participate in the next webinar, which we are thinking that it should take the, you know, the some kind of a talk show format, so that all those stakeholders then will be able to contribute, you know, and have that conversation. We have a conversation where all, maybe we have, you know, the panel of 4 people, and, you know, or maybe more if possible. And so as to have a conversation on this and see as to how we could be addressing this, and more so, not only addressing these challenges, you know, but also, you know, to look into how families could do it better. All right, outside the legal framework. We look at that as well. How do we rehabilitate our families and address issues of solo parenting and end, you're right. So I think this is something that we definitely have to do as Pillar 3. And I can see here Gregory is also here, who's also the member of Pillar 3. So thank you so much for participating, and thank you, Dads in the Picture, and they are called Daddy. They call themselves Daddy, not Mr. So thank you so much. And for those who do not know, all right, as to you know, because I think he did not have an opportunity of introducing himself, but these are the fathers, the daddies that are actually fighting all these issues. So we really need to have a non-genderized approach on these issues and have the voice of a daddy. So thank you so much. And I'm hoping that then we will definitely set a date that's not going to be too far. And we are hoping that with the presenters who have been here, when we have our round 2, they will be able then to say to us as to what is it that they have done, all right, to include or to take heed of the suggestions that were coming from people today. Thank you so much, Daddy Kunene.
Thank you.
Thank you, Mami Praise, for the opportunity. Yeah, and everyone else, thank you as well for your participation. I technically was not supposed to speak after Umami Praise has closed. So have a lovely evening and take care until the next time. Goodbye.